All right, so we're here. Thank you very much for coming to this meeting. This is the group from all of you who work so hard on policy issues in this area. The executive director of Prisology has worked as a client affairs coordinator at the Federal Legal Center, a Florida law firm, and is currently enrolled at the Vermont
On behalf
Law
of Judge,
School.
on behalf of Prisology, Judge Harris, I would like to thank you for the opportunity to appear and provide testimony. Prisology is a relatively new organization. I come to the commission with some unique experience. Like Mr. Nolan, I was in federal prison myself for over 12 years for a series of nonviolent offenses. I was a high school dropout before I went to federal prison. I earned my bachelor's degree while I was there, and I'm now presently in law school, having completed my first year at Vermont Law School. So people can change if they're given the opportunity to do so, and there are a lot of people in federal prison that I believe, and that our organization believes, would seize this opportunity if the commission were to make the amendment retroactive. In terms of public safety, the commission has heard a lot of testimony today, but one of the things that I have not heard is the effect of public safety on children and the family unit. As we indicated in our written testimony, according to a 2008 report from the Bureau of Justice Statistics, nearly 60% of federal prisoners are parents of children. The adverse effects of incarceration on children is well documented and includes but is not limited to increased risk of drug or alcohol abuse, depression, antisocial behavior, withdrawing from school, and aggression. And we believe that through retroactive application of this amendment, the commission is uniquely situated to restore broken family units with their parents that so desperately need that father figure or mother figure in their life. Apart from that, there have been other concerns that have been expressed about the lack of resources to be able to properly implement retroactive application. And one of the potential areas to help mitigate the effects of implementing this amendment on U.S. probation that we identified in our written testimony is for the commission to perhaps give instruction to U.S. probation officers with regard to early termination of supervised release. When we looked at the relevant data, according to fiscal year 2013, there were 131,869 offenders that were on some type of federal supervision, whether probation or supervised release. The vast majority of the offenders each year terminate their supervised release through full term expiration, and according to the data, a mere 13% were terminated via early termination. Yet, while we have these very large supervision caseloads, approximately 40% of the people, according to 2012 data, were on what's called low-intensity supervision. And according to the probation monograph, low-intensity supervision is something that is given to a defendant when their, quote, is likely to remain crime-free, to appear in court, and to comply with all other conditions without further interventions by the officer. So we respectfully submit that there is an opportunity to help mitigate some of the effect of retroactive application of the amendment on supervision caseloads through early termination of the supervised release for appropriate offenders that individual U.S. probation officers are already familiar with, and most likely the district judges have been receiving appropriate reports on their progress throughout their period of supervision. Apart from that, we would also suggest that in implementing the amendment that the commission consider making a requirement that for persons who do not have a family unit to return to, they don't have a place to live or something along those lines, to require the district court to either amend the conditions of supervised release or lower the period of reduction that would be granted in order to give the Bureau of Prisons the opportunity to allow the person to transition through normal pre-release procedures. If that was to occur, that would give the commission the opportunity to be able to allow persons to receive the effect of the amendment come November 1st. In addition, we would also suggest that perhaps with cooperation from the Department of Justice, that the Bureau of Prisons could create a survey, as they have done in implementing the Clemency Project, that would allow offenders to go online there in the Bureau of Prisons and submit their request if they believe that they might be eligible for this retroactive amendment. And from there, with coordination with DOJ, perhaps FPDs, appropriate USPO officials, then take the information and process the request for retroactive application, as opposed to dealing with this perhaps influx of some 50,000 motions or things like that. It would create an additional screening mechanism. And with that, and based on the other written testimony that we submitted, we strongly urge retroactive application of the amendment.
Ask you all, Judge Keeley talked about the balance. She said it correctly. The balance between fairness, between public safety, and between what you can fiscally afford. That's not always coming up with the perfect answer. That you're all focusing on fairness, fair enough. We also have to consider resources. So the question that I have is, if you did anything like a 6-month extension or a carve-out or something to sort of bring into balance all these very important values, what would be the reaction in the prisons? I'm looking at you, Ms. Price and Mr. Sample, because and really all of you who deal with people in the prisons. What would the reaction be? What are people expecting? What's happening there?
Well, I'll give you two perspectives. One being from the family members who follow us, like on Facebook, and I think that there is great anticipation and angst amongst the family members with regard to this hearing and to the upcoming vote, because they badly want to see their family members come home. They have children, they have people, they need that other person in their life for support structure. In terms of individuals that are incarcerated, we receive hundreds of emails a week from federal prisoners discussing the amendment. That you have so many people who are already not subject to the amendment because they either have a mandatory minimum or they're a career offender. And if I will give you, that if this was not made retroactive, my personal sense, having been someone that's been there in federal prison, lived it 24 hours a day, 365 days a year, there's, of course, probably the potential that there are some prisoners that may do some things that they shouldn't do because they are expecting there to be retroactivity. There were problems back in the mid-1990s when the Commission had supported retroactivity, and Congress ultimately decided to disapprove that. And I think that there's the possibility that that would happen. Of course, I don't suggest that that should be the reason why the Commission should or shouldn't take action, but the question was asked, and I think that there is that possibility. And I'm sure that that's probably a concern that the Bureau of Prisons is thinking about, and how do they mitigate, or address those kinds of things.
That doesn't answer the question about carve-outs. That doesn't answer the question about what the reaction would be if, for example, retroactivity were limited to those in criminal histories categories 1 and 2.
There would be disappointment. There would be severe disappointment, and
there would be disappointment for those who are denied sentencing reductions, as there would be if it were fully retroactive. Right?
That's true. That's correct.